So, hold on. There we go. Can you hear us, ma'am? Miss Orr?
This conference room. Hey, Ash. Oh,
Just want to make sure you can hear us, ma'am.
I can barely hear you.
Well, we can hear you just fine. So Erica, I guess just go ahead and go ahead with this case.
Okay.
Go ahead.
In the matter of Orr versus Twig Jackson, docket number 2020-002438-DS. Mr. Twig Jackson has appeared from the Calhoun County Jail today. However, he spoke with a friend of the court prior to the hearing. The case is arrears only and the balance is very low. Mr. Twig Jackson reported that he has an employment opportunity available to him at ASMA upon his release. FOC is requesting the hearing be dismissed, the bond be canceled, he be released forthwith, and that he report to the FOC within 14 days of his release.
Okay. Ms. Orr, did you want to have any input in this matter?
I just want him to pay child support
Okay.
consistently. That's all.
Okay.
That's it.
Court will cancel the bond previously ordered in this matter. Order that Mr. Jackson would notify the front of the court within 14 days or his release from incarceration, and we'll dismiss the action.
Okay.
Okay, great.
Thank you.
Thank you.
Free to go.
Welcome back to Time Serve, the channel that scans the dockets daily so you don't have to. Poor Judge Stevens is always blowing his nose, dropping cough drops, and clearing his throat. And today this defendant comes moseying on in with doctor's orders not to leave his house because he has a deadly and highly contagious disease. I kid you not. So Judge Stevens turns the timeout chair to a quarantine. I swear, you're gonna love it. But first, we begin our daily docket in Judge Brian Kirkman's courtroom, and he has a custody battle where, guess what? People are fighting. Chief Justice Judge McConico, he tells the defendant to hush, but again, nobody listens. Then I have a little bonus from Judge Washington's courtroom. I have no idea what this woman was thinking, and I don't know if she has teeth or no teeth, but she's picking at her teeth. I don't know. Don't forget to hit that like and subscribe and set your notifications to all so you never miss the Daily Docket. I'm your boy Phil. You've been served, and let's get the clips rolling.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. Calling case 2011-2815 DM, Stephanie Bailey versus William Roth. Today is Monday, July 24th, 2023 at 9 a.m.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff and Ms. Greenlee-Clore on behalf of the defendant. This matter is before the court on the defendant's motion to resume court-ordered parenting time. Ms. Greenlee-Clore, go ahead.
Thank you, Your Honor. We're here again on this motion. My client has had this child, primary physical custody of this child since 2013. That was due to Miss Bailey having an insecure household, her having some mental health issues, and her threatening to abscond from the state of Michigan with the minor child. At this point, my client is just trying to get his son back. The parties agreed that while this matter was being sorted out, that Miss Bailey would have the minor child stay with her aunt for a weekend until they sorted this out. Shortly after that, the child arrived at the aunt's. Stephanie went and hired an attorney and filed this ex parte motion. This was never an agreement of the parties that this child was going to go and stay long-term with mother, or that the child was going to somehow start attending school in a different school district. Mother has withheld this child for 3.5 school weeks at the end of the school year, didn't take this child to school at all. This child sat at home. This child has now been interviewed by CPS in her home when that's what she's saying that my client's going to do. And at this point, she's completely withholding this child. My client just wants this child back. Essentially, custody has been changed without a full hearing in this matter. Based on the response here, it looks like Stephanie has now enrolled the minor child in schools in Springfield Middle School. There's no motion pending to change schools here. This child needs to be returned, frankly, to my client immediately. This child is in danger at Stephanie's house. Stephanie has now allowed this child to be interviewed by CPS in her home. She's talked with CPS in her home. And everything that she's alleged that has kept this child with her has now happened in her home. This child is not safe in her home, obviously. She's not protecting the interests of this child in her home, obviously. She apparently plans to change the school district of this child without permission of my client or this court. She's withheld the child from school for 3.5 weeks. This child was an AB student. We don't even know what happened with his grades yet for the end of the school year in Allegan County, but he probably needs to be in summer school. Stephanie hasn't talked to my client or won't talk to my client about that. At this point, there's no reason this child should be withheld. This court last ordered that my client show proof that the CPS investigation and criminal investigation were over. However, there were no investigations. We can't show any proof that these investigations were happening or that they're over because they never happened in the first place. The police did initially do a forensic interview with the minor child, but that's it. Nothing was found. Nothing's going forward. We don't know what happened with Stephanie and her having CPS in her home, but it can only be presumed that it's due to the condition of her home and the concerns in her home that are long-term. And again, this court removed her primary custody for a reason. This child has lived with my client since 2013. There's been no motion to change custody at this point. She has had temporary care of this child pursuant to the court order. At this point, this child needs to be returned immediately to my client's household. My client hasn't had contact with this child. My client hasn't seen this child. This child needs to be returned. If this court wants to do an evidentiary hearing on this, we can certainly move forward at that point. But on a temporary basis, this child needs to be returned to his primary established custodial environment with father. Thank you, Your Honor.
Thank you. Mr. Schaefer?
Your Honor, these are the same issues that were brought up on the ex parte motion and the reconsideration of that. The circumstances were that there were allegations as set forth in the emails from the defendant's household that there was an allegation of a child in his home against this child as to improper touching. And as a result, the CPS got involved, the police got involved. And as a result of the emails whereby the defendants indicated that they were going to have the child talk to the CPS and the police was not in the best interest of this child and was not protecting this child. And that was the purpose of the ex parte motion. As a result, the child hasn't talked to the authorities in this regard. The matter is still pending. The fact that the amount of time has gone by is not demonstrative of it not going forward. And to place this child back in the same household where we have the accuser in that household is not in the best interest of this child at all. This child needs to be protected, and that was the purpose of the ex parte motion. And I think it should continue until there is absolutely no chance that this is going to go forward, and to put the child back into a household where the accuser is still in that household of children is not appropriate for this child. My client has done everything that she can do to preserve the education of this child. She's looking forward for the education in the fall. The child has gotten credit for the year. He is a good student, and to place him back in that household where you have an accuser and you have an ongoing investigation is not appropriate. So we're asking that this matter be dismissed for that reason, and also it's the same allegations that we had before that's been denied.
Your Honor,
Hold on. Who is the accuser, and how is he related to, again, the defendant?
I believe it's one of the children in his home.
That's not true, Your Honor.
Well, what's the accuser's name?
Your Honor, there is no accuser. The minor child at issue here is the one who indicated that he might have done something wrong. The child that he indicated he might have done something wrong to is 3. The child went through a forensic interview and nothing was found in that forensic interview. I want to bring the court's attention to paragraph 9E of mom's response here, where she indicates she talked to CPS and the minor child talked to CPS with her.
Not concerning this matter, Your Honor.
Okay.
And that just further indicates that mother has CPS involvement in her house, and which is one of the reasons why the child was removed in the first place.
Well, we don't know that. It's all just guesswork at this point. So, I mean, we can utilize hyperbole all we want. There's no allegations or anything of that particular nature. Well, the court did initially, when the court did the order, again, keeping the child in the care of the plaintiff, there were obviously some allegations at that particular time. Again, I wouldn't, this matter came back before the court on basically a ex parte motion. I don't look at those as the same as motions that are brought where the parties have opportunity to each, again, allege and to respond. So that is the reason, obviously, that the defendant's motion for ex parte relief was denied, is I wanted to have a hearing on it. I didn't want, again, additional ex parte motions just going back and forth in the case without any time to have any response. What I'm going to do in this particular matter is, obviously, the child is, there's a provision under the other order for summer parenting time. The court is going to continue whatever the summer parenting time is, that would, again, that would commence and continue through the summer immediately in this particular matter. I'm going to then allow the current order, the order for custody, meaning the order, not Mr. Schaefer's order, but the other order, to go back into effect. Court will reconsider that if, in fact, there is something substantial that comes out of a CPS. But if there isn't, then the court wants to put this back on the appropriate footing. And there is, as Ms. Greenlee-Clore states, there's no motion to change custody. So I'm not going to do it under the guise of a pending CPS investigation that may or may not proceed and may not be fruitful in any way. So at this point, do you understand? Again, it's kind of convoluted, but do you understand, Ms. Clore, what I'm saying?
It's my understanding that so I'm looking at the old order here from 2013. It indicates that the parties would exercise week on, week off during the summer.
Yep.
Ms. Bailey's now had the entire summer. Will my client now have his half of the summer, or will they start week on, week off immediately?
We'll do the week on, week off. I can always address any makeup at a future time. So we'll do the, what day do they exchange? Is it a Friday or a Saturday?
Cody, what day do you guys exchange? Just word it.
Friday, and generally Friday to Sunday on her weekends.
Okay.
Well, no, during the summers. Have you guys been doing week on, week off during the summer?
Generally every summer we've been doing half on, half off. We never really did the whole week just because the transportation was easier, but we continued our weekends through the half of summers.
Okay. Well, do you want, I'm sorry, go ahead.
Let's do this, because apparently we can't agree. The court will do the week, as the order said, alternating weeks, starting this Friday, where the child will go back to the defendant. And at the end of the summer, then he currently has custody, so the child would stay with him at that point, unless something else comes up with CPS. So, Ms. Clore, you can prepare that order and submit under 7-day notice of entry.
Thank you. And if I could just specify 6 p.m. on Friday?
Yeah, 6 p.m. on Friday is fine.
Okay. Thank you, Your Honor. I will.
Okay. Mr. Schaefer?
Stephanie, give me a call, please.
Okay.
Yep.
Okay, thank you. We'll conclude this matter at 9:11 a.m. You're free to go. Have a good day.
Thank you.
We'll bring it on behalf of Mr. Tion Williams, Judge.
Argument.
Judge, Mr. Williams' bond is currently $100,000 cash or surety. Your Honor, this is a situation, my client's 35 years of age. You know,
34.
I'm sorry, you're 34? I'm sorry, brother. Had 35.
Okay.
Judge, he has one prior, it looks like from 2011. Your Honor, and unfortunately in this particular case, you know, he's charged with armed robbery, Judge. Police never find any type of weapon, never find any type of gun, anything on him, Your Honor. I'm asking the court to consider, because of his lack of assaultive history, a personal bond. You know, 100,000 cash, Judge, is very excessive. My client has a place he can stay. We do have his brother's information, but I'm asking for the court to consider a reduction down to 100,000 personal. If the court wishes GPS tether, because there was not a tether provision put on at the arraignment, nor was there any type of house arrest. Unfortunately, Mr. Williams lost his job, so he's out working, so he can't, you know, stay in the house until this matters.
Mr. Reagan. Mr.
Pending.
Reagan.
Yes, Your Honor.
And again, we just went over this in the prior case, you know, that the report is a hearsay document.
Absolutely.
But this looks like there was a crime spree going on. Seems like this was kind of a little bit of terrorizing the people, multiple victims, multiple things stolen, bikes, phones, money. You know, this, you know, we talk about danger to the community. Normally we just have one victim and sometimes it's overblown that there's this whole danger to the community. But when we just have random acts of violence and just random acts of just, you know, a person is walking in Palmer, a person is sitting on a bench, you know, and they're being terrorized by two people. It just, you know, it seems a bit much. It seems
There's no evidence.
Excuse me?
There was no evidence found.
Sir. This is not some situation where you just blurt out and you talk. Okay. Now, if you would like to speak, you wait until I finish talking. You let your attorney speak. The prosecutor gets the chance to speak, and then if you would like to speak, then you'll be allowed to speak. But while I'm in the midst of talking to your attorney, for you to blurt out there's no evidence is inappropriate. So let's have a little decorum, and you'll get your chance. Fair? Okay. So what we have in front of me, Mr. Reagan, is again, seems like the definition of danger to the community. And so just want to take that into account for your arguments when you're asking for a personal bond. But Ms. Douglas, go ahead.
Your Honor, we do believe that Mr. Williams does present a danger to the public. The accusations include multiple people, even one, I know it's in Highland Park, but it's part of what appears to be a spree, forcing that person to take off their clothes, Your Honor. It's multiple people, which suggests that there's a danger going forward to other potential victims. And there does indicate that there was some surveillance done where the officers were observing what was happening after a witness stated that that's what they saw. So it's not just the victim saying that it happened. There was a witness who was able to tell the police that it happened. There is a companion case to this, Your Honor. When the case was initially charged, the police had trouble tracking down two of the victims, and or maybe it was two or three of the victims. And so it wasn't charged until the other victims could be tracked down. And so, Your Honor, the other case is already bound over for both Mr. Williams and Mr. Adolphus, Your Honor. And we think that the bond as it is now.
Is that from the same day or is that another spree?
It's the same spree. It's the same spree. They just couldn't track them down.
So how many victims do we have total?
I think it's 5.
5. Okay. All right. Mr. Reagan?
I think you said a key word, accusations. That word you used, accusations. And again, Judge, we are early on in this particular case. I can't speak for other cases. But in this case, we're still early on. We're at bond redetermination. He has other matters. I'm asking the court again on this case to consider a reduction in the bond to a more reasonable bond, Judge, with the tether house arrest.
Mr. Williams, is there something that you'd like to say, sir? This will be that time. Now you have a right to remain silent. You don't have to say anything. Your counsel is now going to advise you that. But I did say after the lawyer spoke that you would have an opportunity if you wanted. Yep,
absolutely, Mr. Williams. And remember, though, anything you say can and will be held against you. Prosecutors on here is being recorded, so yes. I would remain.
I would like to say something.
Okay, but you have that right. But I wouldn't, Mr. Williams, because anything you say, they can hold against you. But you have a right to say something. You have that right.
I really do. I feel like this case that's going on. They say that I was riding on bikes. I was not riding on no bikes when the police picked me up. I didn't have no gun on me, and I wasn't even on no bikes. They picked me up on foot.
Right. Okay. So
I have no. That's what I understand. Just like that gun case. They say it was 2018. It was only a bullet in 2019 in the summer of July.
Yeah, I don't know about that case, Mr. Williams. I don't know, but that's something in the past. But in this case, right? One of the things I wanted to make sure the judge knew is that you were arrested, didn't have any gun on you, didn't have any
like that
on it, any type of, weapon on you or anything like that. So that's the first thing we wanted to make the judge aware of, and I think that's important. So
that's very important.
It's very important. So what we'll do is, make sure that that's part of your defense. You did not have, you had no weapon. I mean, I
had no weapon on me when the police pulled up on me. I had no weapon on me, and then they told me I was riding on bikes. I was on foot when they picked me up. No bikes, bikes at all.
And that's another discrepancy. So that'll be something that'll be pointed out later. You were on foot, not on a bike. So that's something that's wrong in the report. So those two things will be definitely emphasized at your next hearing, I believe. So this particular one, I think, is done right now. Judge, unless you are you considering the tether with the house arrest, the 100,000 personal? Are you considering that?
Printer and was spitting. So was it? I get, just to make sure we're clear on all this stuff. So
yes, sir.
Was it Mr. Williams that was accused of spitting on the MDOC staff, or was that Adolphus?
That wasn't me.
Okay.
He was accused. That was allegations, Judge. Still, allegations.
Williams pointed a gun.
It says defendant spit at officer Williams. Defendant Williams spit at Officer Smith 4 times. However, it did not make contact.
Okay, I'm just trying to figure out and who was supposed to be on the bike and all that. Anyway, court haven't heard the arguments of counsel as well as Mr. Williams' statements. Court finds that the 100,000 cash bond is an unaffordable bond. Court finds that, the court states that if there's going to be an unaffordable bond, there has to be a showing of either flight risk or danger to the community. Court finds that there is a definite danger to the community based on these allegations and based on what we have in front of us at this point. Court finds that the bond that was set by the magistrate is an appropriate bond for the protection of the community, and the bond will continue. Thank you.
Your Honor, with this bond, there is a tether, but I don't have it as having any conditions.
If the defendant makes bond, the defendant will be placed on house arrest with the conditions of he can be released from medical appointments and court visits, medical visits and court hearing.
Thank you, Your Honor.
Thank you. Okay. All right. And what's your name, young lady up top? Is that Giovanni or is no? No. What was her name?
I believe so, Your Honor, yes.
Kevin Mantalini, not here. Let's start off with Arthur Washington. Arthur Washington.
Did you have some? Oh, you did.
Arthur Washington in 23 CR 197. What about that? Arthur Washington. Okay, we have 23 CR 197 Arthur Washington. Is that you?
That's right.
You are charged here with the third-degree felony of assault, family violence, which carries with it up to 10 years from prison if convicted. Are you getting a lawyer?
Yes.
Who?
I don't know.
No.
I just had tuberculosis, so I wasn't able to work.
Look, I'm looking here at county multi-purpose bond. So you got a bondsman out of Orange County in April, okay? May, June, July. 3 months have gone by. You don't have a lawyer yet?
No, I had tuberculosis. I was on quarantine. I wasn't able to work.
Okay. You were able to afford $20,000 on a bond. We don't wait for you. We move forward. And if you're not on the ship leaves. That's the way it is. And we got too many cases filed every week. What is that? What's this indictment mean? Previous conviction, I guess.
Yes, sir.
IAT? What's IAT? I've never seen that on an indictment case, ever. Only 43 years doing this. I never saw IAT. What does that mean?
I believe it stands for if at trial.
What does it mean?
If at trial.
It means what?
If at trial.
What does that mean?
I don't know.
Oh,
I just told you.
did you just make that up?
No, sir.
I think you did. If at trial.
He's practically a walking thesaurus.
Previous conviction, if at trial? What does that mean? That doesn't mean anything to me. That's nonsensical.
Yeah, I did not see that is how they captioned it, Judge. But I can, it is based upon a previous conviction.
Of what?
Of
the December 16th, the county court at law, you think? That's
yes,
what
sir.
that is?
Yes, sir. That is how the state will have to prove it. Yes, sir.
All right. So where are you working?
I'm not working right now. Just
what do you do?
Quarantine. I was on quarantine with tuberculosis.
Well, when are you going to start working?
When they let me out quarantine.
When is that?
They said in November. I asked them the same thing.
Yeah.
They said.
Well, you're on quarantine for what?
Tuberculosis.
For why? So why the hell are you here in court if you're in quarantine for tuberculosis?
Because if I don't come to court, then I have a warrant.
So you're going to give everybody TB?
So I'm not supposed to come to court.
Well, you're supposed to wait. There are certain things you don't do. I see. You don't go out and get a lawyer, but you come to court where everybody else is dealing with their cases. Does that make sense to you?
So
what did your bondsman? Did your bondsman say you got tuberculosis? Go.
No.
Okay. What did your doctor say about this?
On quarantine.
What does that mean to you?
Not to go nowhere.
But you're here, so you disobeyed your doctor's order. Why don't you even have a mask if you've got tuberculosis, sir? Sit over there. Sit over there, right over there. You're in quarantine. You're quarantined over there. That's terrible. You don't have any common sense to do better than that? The doctor ordered you to do certain things, so you quite naturally come to court and expose everybody else to tuberculosis? or whatever it is, But you're able to. You can't go get a lawyer. You can't take care of your business in your criminal case, but you show up to expose everybody else in the community. Yeah. Does that make sense? You don't work, right? You don't have a job because you can't. You're quarantined, but here you are. You've unquarantined yourself for this. There is always an excuse not to come to court. That is a good excuse if it's for medical purposes. That's common sense. It doesn't even have to, it's so well known, it doesn't even have to be written in the book because everybody on the planet except you knows about it. Just, why would you hurt other people or expose other people? Just give each person the respect that they are owed, and that is don't expose them to a serious illness. I want you to go outside, sit, and we're going to go bring you a resetting. And when does the doctor say you're not under quarantine?
Well, I have to take medicine until November, so I'm just waiting until they clear me.
Well, like every day they could clear you, or when?
Any day they can clear me.
All right. This case involves an Amber Robinson. Who is that?
That's the mother of my children.
Okay. Where is she?
I'm taking she at home with my kids.
You don't know?
No.
Where do you live?
I live in Orange.
Okay. That's different from where she lives.
Yes.
You can't have any contact with her.
Yeah.
Do you have a GPS device?
Yes.
On you?
Yes.
Let me see it. It's not on you?
Well, like my phone? This the only thing I have GPS on?
That's not, no. It's supposed to be attached to you.
Oh, no. I don't have it.
Yeah, you do. That's ordered. I just ordered it.
Okay, now it is. All right.
In every case like this, it's ordered so that we know you're not going to see somebody.
Okay.
Because you can sit your phone there and go around town. When a court orders, like it orders in every case like this, a GPS device, you have to have it on your person. So we know where you are at all times. You have 48 hours to do that. And I want to see receipt of it, or else I'll issue a warrant for your arrest. Do you understand?
Yes.
We're going to send you a resetting for 30 days. You call us and tell us what the status is. Also, we want something from the doctor, from your doctor, giving us a status. This is an important case. We're not going to wait around.
Okay.
And you're going to follow the rules. It's kind of, maybe your Orange County bondsman didn't know the way we do things here, but they generally are pretty aware of how we do things in Jefferson County, which I believe is cutting edge way to do it. And that is a GPS device. I mean, give me a break. A third grader knows how to get around that. It's on my phone. So you'll know where I am at all times. I'll leave it here when I go out, when I'm not supposed to be near somebody. That's just simple. But you're in big league court. You're looking at up to 10 years in prison. Have you ever been charged with a crime before?
Yes.
For what? You're thinking about it? I mean, I'd know. What were you charged with? I'm not talking about speeding,
Not family violence, misdemeanor.
A family violence?
Yeah.
The same lady?
Yeah.
That's this case in 2016?
Yes.
That was in Jefferson County.
Yes.
And so we're back with the same victim?
Yes.
Who set this bond, please?
Judge Doyle.
May not have seen the probable cause affidavit. Here's here's the court orders of the day. You live at 3708 Ridgemont
Yes,
alone?
yes,
All right. That's where you're confined. You shall not leave that location except to see your doctor or to get food. You understand?
yes,
Or to come to court. You have to have a GPS device. I want a GPS device. I said 48. You got 24 hours because I don't trust you after reading this. Especially when you have previously been convicted of a similar offense. You don't treat a lady like this. Of course, that's an allegation. You're going to be, I want to know what the status is in 30 days. I want a doctor's updated report brought to this court before your next court date and provided for us. And if you're unable to appear in court, we'll reset it. But I want to know, I want updates. Do you understand?
yes.
Because you're slipping through the cracks. And I know that's what you want to do, but you've done something that you really don't want. And that is you have my attention, my 100% attention for you. Get a GPS device. You fail to do any of these things, a warrant will be issued for your arrest. Your bond will be zero. You will sit it out in jail, sequestered, I guess, until you can be allowed with the other inmates. But until we can dispose of this, that's where you will be if you don't follow these rules. Do you understand?
Yes.
Your nonchalance doesn't cut it with me. There's a serious illness we're talking about and a serious case that you have allegedly repeated. And you're sashaying through life thinking those aren't important. But I'm going to make sure you understand and appreciate they are. Because it seems like you really don't care about others. It's only about the guy in the mirror. Get a reset. Iona Brown, please.
Next sign is around the edges.
Thank you so much.
So, Your Honor, in light of that, the offer would be in case 22W5954, I would amend, add account 2, the civil infraction impeding traffic. He can admit to that civil infraction. I'll dismiss the original count 1, and I would also dismiss the other case in its entirety. Is that what? That's not a state case, though, is it? I guess
No,
attorney of record is Kevin.
it's labeled ST, but it's a W, so I believe that's a township case.
Mm-hmm. Let me look at the ticket just to make sure.
I don't want Miss McDuffie to get mad at me for.
No, you don't want that. It is a township case.
All right, so I'll dismiss that other ticket as well.
All right. Is that what your client would like to do?
I believe so. Mr. Smith, is that correct?
Correct.
All right, sir. So you're going to accept responsibility in case number 22W005954 for an impeding traffic, which has a fine of $180 for an offense that occurred on December 6th of 2022 at the vicinity of East Michigan Ave and Burbank Ave here in Ypsilanti Township. Is that correct? Did we just lose him?
I see him at his videos off.
Yes. Is that correct, Mr. Smith?
That's correct.
All right, thank you. Fine is $180. Can you pay that today, sir?
I cannot pay that today.
How long do you need to pay, sir?
I say like 2 weeks. I can have it in 2 weeks.
Mhm. To be paid by August 11th.
Okay.
And then I will bring you back here on August 30th to make sure it's paid, okay?
Okay.
If it is paid, you don't have to be here.
Okay.
All right, count one is dismissed. You're all set, sir, along with ticket number 22W000440. It's also dismissed. You're all set, sir. Have a good day. I think he's gone already. That his wonderful day. Oh, it's just this. Okay. The court will call the Latasha Rogers matters 23T 000-036 14W 199186 as well as 16W 008397.
Paul Barnett on behalf of the township.
Assistant Public Defender W. Leba on behalf of Miss Rogers in this 3-6 matter.
Thank you. All right, Ms. Rogers, could you please state your name, ma'am?
Latasha Rogers.
Good morning. All right, we are here on these matters for a pretrial and 2 show causes.
Yes, ma'am.
Okay, go ahead.
Yes, Your Honor. With regard to the pretrial, we request one final adjournment. We have not received an offer that we are prepared to accept. So
5 minutes later.
So I'd like some additional time to discuss with Ms. Rogers and consider our options.
I don't object to one adjournment here. That's fine.